In 2012, the D.C. Circuit Court heard a challenge to an FDA rule that required graphic health warnings to be placed on all tobacco packaging. If any of you have traveled to England or other places, you may have seen similar kinds of graphic health warnings. Now, if I gave this to you as a scenario and asked you if this law was constitutional, your first move should be to think about the flowchart. Now, if I were doing this, I would say this rule compels companies to disclose information to consumers. Now, normally, if the government is scrutinizing a law that requires disclosure, it's actually a little bit closer to rational review because it's not restricting speech. It's merely saying you need to actually provide truthful information to the public. So I thought it was interesting that the DC Circuit Court framed it as a restriction on truthful commercial speech. In any case, it decided to use Central Hudson. Normally, honestly, that's not what you should do, but you could actually just jump straight up to relaxed scrutiny and say, I can tell that because this is restriction on advertising, truthful advertising, so I'm going to do a Central Hudson analysis. Now let's look at how the court made that announcement in its opinion. It said, under Central Hudson, the government must first show that its asserted interest is substantial. But then look at what it said in footnote 11. Central Hudson also provides that commercial speech only receives First Amendment protection if it's a lawful activity and is not misleading or fraudulent. Neither party seriously disputes that, so we're good to go. So it is actually doing that initial Central Hudson question. It's saying, hey, we've thought about this. It's restricting truthful advertising, so we're doing Central Hudson. And of course, at Central Hudson, the first question is, can the government prove a substantial government interest? And here too, you can see the court discussing this. Unlike rational basis review, what we call in our class rational review, Central Hudson requires us to be a little bit more picky in our scrutiny. So then it discusses what exactly the FDA's interests are. And it notes that the only thing that the FDA acknowledges as a government interest is an interest in reducing smoking rates. This DC Circuit Court is really skeptical about what the government interest is. Footnote 13, like the district court, we're skeptical that the government can assert a substantial interest in discouraging consumers from purchasing a lawful product, even one that's been conclusively linked to adverse health consequences. But then it continues, well, but the Supreme Court has basically said that it is okay for the government to have an interest in reducing smoking rates because smoking poses perhaps the single most significant threat to public health in the United States. It's saying we see two prospective government interests. One is that the government is trying to discourage individuals from smoking. Now that's Posadas kind of paternalistic rationales. In other words, we have to protect you from yourselves. In Posadas, that was allowed, but then 44 Liquor Mart killed that. That is no longer a legitimate, substantial government interest because it's paternalistic, it's condescending. Now, the DC Circuit Court kind of thinks this is the real reason. But since the FDA has never actually said that, it has to go with what the FDA claims its government interest is, which is a policy issue. Smokers have been creating a huge health crisis and is a policy issue that is expensive for us as a nation, et cetera, et cetera. So they accept the second one as the government interest and reluctantly say, okay, we suppose this passes constitutional muster. Goes on to the next question, will it directly advance the government interest? We're going to evaluate whether the FDA has offered substantial evidence showing that the graphic warning requirements directly advance the government interest asserted. And of course, they are quoting Central Hudson. Notice Florida Bar v. Went for it, and where's another one? And Rubin v. Coors. So of course, you guys saw these throughout the entire opinion, all of these other commercial speech cases. And to make clear exactly how it's going to apply this question, kind of what level of scrutiny, what level of pickiness, it notes that a restriction that provides only ineffective or remote support for the government's purposes is not sufficient, and the government cannot satisfy its burden by mere speculation or conjecture. So this paragraph between Florida Bar and Rubin v. Coors is saying we are going to be somewhat picky. This is technically relaxed scrutiny, but we know the commercial speech cases, so we're actually going to be a little bit stricter in how we answer this question. And of course, its answer is pretty unequivocal. The FDA, it says, has not provided a shred of evidence, much less the substantial evidence required by the APA, showing that the graphic warnings will directly advance its interest in reducing the number of Americans who smoke. And it cites the studies that the FDA had brought up and said, sure, you've shown us these studies, but people thinking about quitting smoking is not the same as people actually changing their behavior and quitting. You would have to actually show us that behavior had been changed. So at this point, I want to have you recall Brown v. EMA. That's the video game law that California passed. It was just a video game sales restriction for minors. The majority of the court, as represented by Scalia, demanded that the research show an actual direct causal link between video games and behavior change. And because this is social science and media effects are almost impossible to prove conclusively like that, because we are all such little snowflakes, California's law was struck down. Brown v. EMA and this case, theoretically at a different level of scrutiny, both of them, the courts are demanding scientific evidence to support any sort of speech restrictions. And this isn't even a speech restriction, it's actually just requiring labels. So if I were writing an answer, I would say, at the second prong of Central Hudson, the D.C. Circuit Court rejected the FDA's evidence. It demanded proof that the graphic labels would concretely reduce the population of cigarette smokers and said that the FDA didn't have a shred of that proof. Evoking thoughts of changing behavior ain't the same as changing behavior itself. Even though these labels have been used in other nations, no one can show a concrete link between labels and a decrease in smoking. So that's one way that you could answer that question in terms of reporting how the court did the analysis for this question. Final question, is the state action narrowly tailored to achieve that government interest? So I know you were all looking for this. You're like, okay, where's the narrow tailoring question? They never brought it up, right? I know, it's such a trick question. So the DC Circuit killed the graphic warnings label requirement at the directly advanced prong. It never bothered to ask whether it was narrowly tailored. So that's what you would say there. Now see, I like this because at this point in the class, I'm hoping that you guys trust yourselves enough to be like, dude, they obviously just didn't go on to the last question because they already killed it the second one. A concept that we've been practicing all semester in various judicial tests. So hopefully, rather than go crazy, you're like, oh, I see what's going on. They're just not even going to bother talking about it. Now, personally, I prefer that they show their work, but they're not returning my calls. What can I say? So here's how an answer could look. Good to make little headings that actually ask the question in your answers. To get full credit when you address substantial government interest, whether it's Central Hudson or anything else, what I want you to make sure to do is actually tell me what the government interest is and then tell me whether it's substantial or not. So here in the answer, I see lower the number of current and prospective cigarette smokers. That is what the government interest is. I want you to tell me what it is, and then it's going to pass. So as long as you address both of those things, you're solid on substantial government interest. And of course, remember, substantial government interest, unless you see a Posados or a 44 Liquor Mart kind of disfavored product kind of rationale, then go ahead and give the government substantial government interest. Remember, there's just a whole array of possibilities for that. And as long as it's not crazy and as long as it's not condescending to the public, then it counts. Next question, will it directly advance government interest? On the final exam, the thing that you need to do to get full credit is to acknowledge Florida Bar. And tell me at this question, the court's going to be pickier than what we're used to seeing. Okay, so if you mention Florida Bar, that's a really good idea. But basically tell me the courts are doing more heightened scrutiny here. And here we actually have the level of what counts as directly advance. So what the court said is, here's our standard for directly advance. It has to actually reduce the population of cigarette smokers. The FDA has failed to prove that. Now, if you want to, you're welcome to do what the DC Circuit did and just say, I am now killing this here because I don't have to go on to the third question. Is it narrowly tailored? Here you were able to just say they never addressed it, but it's a really subjective question. Unless it's a complete ban, I would say, it's probably fine. So the fact that you ask the question is the important part. And if you've already killed a restriction by the time you get there, you don't even have to do that.